We ended with the Yoder dissent last class. So just to sort of review a little bit. What was the issue before the Supreme Court in Yoder?
The one I got straight out was, this Wisconsin v. Yoder, right?
Yes.
Okay. Whether respondents' convictions for violating the state's compulsory school attendance law were invalid under the Free Exercise Clause of the First Amendment made applicable to the states.
Okay, so who were respondents?
The student, those three students? Jonas, Yoder, and Wallace Miller. And
With
their-
the petition, I'm sorry, were the parties in Wisconsin v. Yoder?
Jonas, Yoder, and Wallace Miller are the two students, they're members of the Amish religion.
The students were the parties.
Respondents in the state of Wisconsin.
Anybody disagree?
Sorry, I might be.
Nick?
State of Wisconsin.
What, the state of Wisconsin was one party. Who was the other party?
Oh.
Wasn't the children?
It was the parents.
It was the
Okay.
parents.
Oh, well.
So you were correct, except
That
that
they're
you, for your
yeah.
designation there. So it was the state versus the parents.
Gotcha.
Because as distinguished from, was it Douglas who dissented? I forgot. I gave you the dissent, right? What does the dissent bring up that's sort of now our new chapter? I mean, we started with Meyer, Pierce, Prince, and then the Yoder majority, which basically balance, family versus state. And notice what I put on the board is the three sides of child, parent, state. We'll throw up some of the cases in a minute. So I've got under parent, protection from the state, right? Meyer, the teachers and the parents' right to instruct in the German language. Pierce, the family's right to send the children to private school as opposed to the compulsory public school education law. Prince, protection of the state, right? The state having the compelling interest in protecting a child from child labor in spite of the parent's substantive due process right to bring up the family, as well as a First Amendment right to practice her religion, Jehovah. So actually, let me throw this on the board. So Meyer, protection from the state, right? It's a parental win, so to speak, a family rights case. Pierce, the same, a family rights case. Meyer, we'll just say instruct German language. Pierce is the private school. Prince is the protection of the state. Child labor versus parent due process and First Amendment rights. And where am I putting now? We're in Yoder. So where does Yoder go in this? Is it a family rights case, a states' rights case, a child's rights
It would be
case?
parents' rights, although the dissent says it should be
Yes,
child.
exactly. So we're gonna put Yoder majority, the right of the parents to Amish parents to pull their kids out, what was it, about 14 and up?
Yes, 14 and 15.
Pull kids. In spite of, right, in spite of the state's compulsory education law. And Nick, put, he said, the order of dissent, and that's where we are right now with our conversation. The dissent bringing up the right of the children to religious freedom, even though, or is it, was the parents' motion to dismiss at some point had asserted the children's rights as well as the parents saying that, hey, you know, we know what's best for our children, bringing them up in the Amish religion, and, you know, we shouldn't have to comply with the state's compulsory education law past 14 years old because of our history and tradition and blah, blah, blah. And we're asserting not only our rights as family, but our children's rights as well. What sort of spin does the Yoder dissent put on that, Nick?
Well, it's saying that you're upholding the parents' religious liberty, and by doing that, you're basically imposing the parent desires on the children. But the children are pretty much old enough to make their own decision, and they had a statistic where, say, 30% of the Amish children leave the community anyway. So they're saying that because they can't go to these high schools, that living in these communities, even though they want to leave, imperils their ability to actually succeed in the real world after, you know, not having education after the 8th grade. So they're saying they can't survive outside of the Amish walls of the community. And that's a concern to the state and, you know, the upbringing of its
So
citizens.
the Amish child has, is able perhaps to voice a different opinion than the parent, and the child is old enough, the state may be able to override the parents' religious objections. But why should the children be entitled to be heard? I mean, isn't the fact that they are children warrant that somebody else, parent or state, should be able to speak for them? I mean, up until then, sort of that point in time in American jurisprudence, that was the case, that someone else spoke for children, right? This is one of the first indications that perhaps there should be a voice coming directly from children. But I mean, again, just the fact that they're different, and we keep coming back to that very simple fact in terms of jurisprudence of child law. They're different, they're not little adults. Why should they be entitled to be heard directly and not have somebody sort of that knows what's best for them speak for them?
I do think there's like a certain age, and this came up a lot when I took family law, that sometimes judges won't give so much weight to a child's decision on who to live with in like a divorce, for instance. But depending on their age, maturity, you know, they have an opinion. But I think at a certain point, as they get older, they do start to think for themselves, and it's not so much on the parents to be guiding them in a certain direction all the time. But I do think up until a certain age, your parents are basically your biggest advocates.
So represented, you just mentioned their names too, was Vernon, Yitzi, and the older children, Barbara Miller. Suppose you represent them, and so they're saying they want to go to high school, the opposite of what their parents are saying.
Mm-hmm.
What kind of argument would you make for them?
I mean, at
In spite
14,
of what yeah, go ahead.
at 14, I think that, I mean, 14's not, you're not necessarily an adult legally yet, but you've had 14 years living and, or, you know, being a part of the Amish religion, and maybe 14 is old enough that you can like maybe decide you would rather go to a public high school and not, you know, start to kind of create your own path outside of what your parents might want for you.
So how do you balance that with the parents, again, not only substantive 14th Amendment right, but First Amendment right to practice the religion and bring the family up in that religion? How do you balance what you just said with the parental right to?
I mean, is there
make your argument.
a certain age or a certain standard that once children do reach, I think in this case they said it was what, 14? Are they old enough then to maybe know what's in their best interest? As opposed to like, of course their parents are always gonna say like, I know my kid better
So
than anyone.
are we
but-
talking about right now the children's actual decision? I'm sorry, I'm not phrasing it correctly. are we talking about, yeah, the argument for deciding in children's favor, deciding in favor of what children say they want? Or are we talking about just merely listening to what they have to say? In terms, again, of sort of children's rights. Yeah.
I don't know, I think it's tough to say because the Amish have their own community, so that's like all they know. But like to people like us, you know, when we want to go to high school, we apply to different high schools and all that, and our parents say, well, which one do you want to go to? And we, you know, we're like 14, 13 years old, and you make that decision. I
But
don't
so
know.
who makes the decision?
I mean, I
In the
guess
end,
the parents could if they wanted to be like, no, you're going to this school, whatever.
I'm
but-
paying and you're going here.
Right, but when it comes to the Amish, it's different because, I mean, that's like the one lifestyle that everybody around you does, and, you know, to go to the outside and actually go to high school is like not the norm. So I don't know what in their society or their religion that is acceptable. I don't know if that's like, I don't know, difficult, because 14, you should be old enough to, you know, make a decision about certain things, but there seems to be a cutoff somewhere, and it's not very clear.
Okay, John Paul
I
Hennessy.
think the case talked about the mandatory requirement, a compulsory
The compulsory education law,
says
right?
that, yeah, up to age 16.
Mhm.
And the case also said how this was also constitutional because it falls within the government power. And the question, the big question is how you balance that constitutional, the state power and also the parents' rights and also the children's rights. But at the age of, if there is there was that requirement that at the age until the child reaches the age of 16 has to be, there is a formal education that is outlined by the states, and the state says that it has the government power to regulate, the constitutional power to regulate the education up to age 16. But I also agree that
By the way, what's the test because of the nature of the parental right in Yoder when you're talking about the state's interest in the compulsory education law?
the test, whether it does interfere with the freedom of
Yes.
the
Yeah, what standard should the courts use in evaluating or deciding whether the parental right takes precedence or the state's right takes precedence when the parents have a interest that's similar in Yoder, similar in Prince, unlike Meyer and Pierce.
I mean, the test that's supposed to be used.
Yeah, the standard.
For instance, you mean the rational basis, and first the high standard scrutiny.
So it would be a higher standard because the Yoder parents are articulating, arguing the First Amendment right to
Yes.
practice their religion. Same as Sarah Prince argued as well. Yet you have a decision favoring the state in Prince, favoring the parents in Yoder. And I know we kind of got into that a little bit last class. Go ahead.
No, I wanted to add to complete what I was saying. They said it went against, we didn't rule the same way because here they're talking about.
When you say here, what do you mean? I just want to make sure.
In this case, in this particular case, the Yoda, they said it wasn't the religious interest of the child at the time. When they ruled, they were not looking at the religious interest of the child. It was the parents.
Correct,
This-
and in Prince as well.
In the Prince, it was also the parents' rights.
Yeah, remember Prince, so you had Sarah Prince walking outside Sunday night, distributing Jehovah's
yes,
leaflets, and state of Massachusetts, all the way up to the US Supreme Court, which said that, you know what, she may have some, very good fundamental interest, or parents may be free to be martyrs themselves So she can put herself out there on a Sunday night, distribute leaflets and maybe get money for it, but she can't make her kid do it because we've got this child labor statute that's supposed to protect children, right? Yoder, we have another statute, and it's the compulsory education statute. But the rights of the parents in Yoder are identical, right-wise,
That's right.
right, to the parents in Prince. Yet, state wins in one, parent wins in another. So what is the distinction? Why do the Yoder parents win?
I think I tried to say this last class, and maybe I just didn't articulate it right. And I don't mean to keep coming back to it, because I really have no
No,
knowledge.
keep coming back.
I really have no knowledge.
Because these cases sort of set the basis too, for
Of-
what we'll talk about in terms of the care and protection later on, and the chins, the delinquencies, yeah.
Because I don't have any knowledge of Jehovah's Witnesses or the Amish religion.
Oh, okay.
Other than, I think that when you are a member of the Amish community, like, it is a lifestyle, and I know that you could say that for a Catholic, or
Or any religion
yeah,
that's
but
considered for,
they don't go to regular schools, and they don't, you know, they live life in a totally different way, and I think that transitioning out of that into a public school, it is a big step, and I think, I mean, I don't mean to say it like this, but that it is a much bigger step than like walking from your house to distribute like materials on a busy street, you know, and
Mhm.
I know it probably doesn't turn on that, but when I think of the Amish, like I think that what these kids are trying to do, it is a big deal to like transition out of a lifestyle that you've known for like 14 years, and I could see maybe why their parents are concerned about them, because that's a big deal.
Okay, so good point, the distinction between the two religions. What about the distinction between the two states' interests? Is that where you were going to go with?
Yeah, in Prince, it's the child labor, all about, you know, having harmful effect, child labor on the kids. But in Yoder, it's the mandatory education laws arose largely in part as a means of preventing harmful child labor to the kids that don't go to high school because they have to go and do work in the Amish
For the
community.
very young?
Yes,
Okay.
so there's no evidence that the Amish children at that age were subject to any harmful labor, so the parents will win out because they're not really harming children as they were in Prince. So it's like the child labor law, and that in Prince is, you know, warranted, as in Yoder, the parents have the right towards the education of the kids because there's no harmful child labor involved.
Okay, so a little bit, so Elizabeth just articulated sort of a little bit of a distinction between the religion of the parents in the two cases. And Nick, you're looking at the distinction between the state's interest in the two cases. And I mean, what kid, this is very simple, but what kid could die as a result of not going to school? Yet a violation, when you think of child labor, could seriously harm a child. And as you look at other cases, that becomes also the basis for the state being able to intervene in abuse and neglect cases, because the child's welfare is so much at stake, you know, in spite of the fact that a parent is, you know, has a valid argument as to his or her due process, as well as maybe religion. Jump
I
on.
agree with Nick's, the labor, I think they took a different approach, because this one is, the current case, the Yoda case, they said that the Amish agree with the mandatory. They also agree with the mandatory.
That's right.
So that also gave them an advantage. And also, except for they have their own way. They have this mandatory, but also they have preferences of how their children should go to school. And as opposed to what Nick just mentioned, and the other one was just a violation of labor law, which is completely two different things. It's here it's just how we do it, but they agree that it should be done. But the other one was a violation of the state law.
Okay. Now, did I give you Dr. Couple next, or is Troxel
Yes.
next on your, Troxel?
So Troxel is next.
Okay. I'd like to go through these two fairly quickly, just so we can also go through Galt fairly quickly, just in terms of the holding and understanding the case, so we can actually do the little hearings next week, okay? So, I'll do the traditional thing and ask somebody to volunteer to start talking about Troxel.
Oh, well,
You will? Okay, thanks,
Church
John.
or-
Oh,
go ahead.
I think it was
go ahead, you can start.
parental rights. I say, who has the right to apply for child custody? Whether the grandparents had the right. So it was two people. They had a brief relationship, and they had 2 kids.
Mhm.
Eventually, they broke up, and the man committed suicide. So the man's parents wanted visitation rights to the kids, to the 2 girls, to the children. However, the woman or mother wanted them to have.
So mother's Granville, Troxel's are grandparents,
Yeah,
correct?
the paternal grandparents, yeah.
Yeah.
So she wanted them to have like one visitation right per month. And so they filed they went to court to get an order.
Okay.
So at the lower court, they won because they found that it was in the best interest of the children.
So, and that came from a statute, right?
Yes.
And what did the statute it kind of defined the procedure, right, for allowing the grandparents' visitation?
If there was a pending,
You started it when you said best interest. Anybody want to help them out? What did the statute
say
say?
that it talks about the interference with the fundamental right of parents to rear their own children?
No, the statute itself, the Washington statute, John?
Any person may petition the
And
court
so that
for
was the
visitation
grandparents.
rights.
I'm sorry, go ahead.
Any person may petition the court for visitation rights at any time, including but not limited to custody proceedings. The court may order visitation rights for any person when visitation may serve the best interest of the child, whether or not there has been any change in circumstances.
Okay, so, I mean, you essentially said it before, William, when you said the best, so that was the standard for granting visitation. So what happened? You want to keep going?
okay. So at the appeals court,
So wait, so the lower court gave them visitation rights?
Yes.
Okay,
because they found it in the best interest of the child. But at the
Okay.
appeals court, once the case, before the case even ended, the kids were adopted by the new lover, the new man.
yeah. So,
the appeals court found for the mother.
keep going.
And,
You want me to help you out?
yes.
Yeah.
The appeals court reversed the lower decision. Basically said that non-parents lack standing to seek.
So wait, let me just interrupt. What was the mother's beef here, really?
The mother's beef, she didn't want to cut off the visitation, she just wanted to lower, I think. Lower, she was gonna let them visit, I think, 1 weekend a month, and I think a week during the summer or something.
Mm-hmm.
So it's not like she was gonna cut it off totally, but I think the beef, so to speak, was she got remarried and
And that's what William said,
and
in so many words.
tried to move on, I think.
Uh-huh.
You know, I think the father, the guy she married or whatever, adopted the kids. So I think it was more or less, she wasn't cutting out the visits, she wanted to just minimize them.
Looks like Elizabeth wants to
Oh, I
help.
just was, just to add to that,
Mhm.
she felt that it interfered with her right to decide what's in her child's best interest. And the court didn't, or the lower court didn't really give any weight to the fact that she was a fit parent, she
Mhm.
wasn't deemed unfit, like she can determine who her child spends time with, and she basically argued that parents have a fundamental right to make decisions regarding the custody of their children.
So obviously, this case, again, similar to the other cases, a case where the court is examining a statute, right? And trying to make a decision whether that statute violates parental rights. So how did that statute violate her rights? If she's not losing custody, the statute deals with visitation, right?
Yes.
So how does it violate parental rights?
Parents have the right to decide on visitation, how long, their own kids. That's how I think it violates our rights.
Okay, put it in constitutional terms. Everyone's hand went down when I said that.
It's very difficult, but
Okay, next thing.
Take a stab at it. I think it goes back to the parents having, I know you told us not to use this word, but fundamental right in the rearing of the child, so the state can't grant any.
Substantive due process, liberty rights
Right,
of
it
the
would-
family.
The state granting visitation rights, even though it's in the best interest of the child, violates due process, because if those visitation rights are opposed by the child's parents, then the parent wouldn't have the fundamental right to do what's best for the kids, so like what they have that
Now, this case,
right.
even though it's decided in the year 2000, quotes and uses the cases that you just read from the 1920s. The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. This is Meyer. We held the liberty protected by the due process includes the right of parents to establish a home and bring up children. Pierce. We again held that the liberty of parents and guardians includes the right to direct the upbringing and education of children under their control, and so forth and so on. Yoder, we recognize the fundamental right of parents to make decisions concerning the care, custody, and control of their children. So the court is looking back, right, to the earlier precedent, again, to articulate the substantive due process rights of the family, in this case, the mother, is violated by a statute that basically did what? What was really wrong with it?
It's overbroad. I mean, it says any person can apply, I had it in front of me, at any time, but it doesn't tailor to a specific group that can apply for a petition for custody. It just uses the word any, which literally could mean anyone.
And who just mentioned fitness before, a few minutes ago? That's another term that we'll get into a lot as well, the fitness of parents to have, basically to be able to rear their children, basically without hurting them, neglecting them, abusing them. And, you know, parents are sometimes found fit towards, you know, one child but unfit toward another, so it goes into the relationship between the parent and the child as well. And the court talks about the presumption that fit parents actually act in the best interest of the children, yet the statute left that sort of best interest standard with the judge to decide. So it isn't as if, and we actually have a grandparent visitation statute in Massachusetts, so it isn't as if grandparents don't take away from this, that grandparents cannot be able to intervene and to you know, get visitation, but it has to be, you know, within the parameters of family rights and, you know, not be overbroad, not violate, you know, a fit parent's right to, I was waiting for somebody to say she really wanted control, you know, and she may have been perhaps too controlling, you know, she couldn't stand them, they were on the other side, but they're still grandparents, they still should have some rights. But again, within a statute that's not as overbroad. I'm sorry, John Paul.
Yeah, there's something that I thought was important in this decision, even though the statute of the 2610 160 said, but also they said when the Court of Appeals reversed the decision, it says the non-parents lack visitations under the same statute, lack visitation, unless the exception is only when the custody is pending. So if that wasn't present in this particular case, then the statute didn't really give them the right to seek visitation, and instead it lacks standing. The grandparents also lack standing, according to the statute itself.
Okay, good point. Also, you know, we're throwing around that word fundamental again, and I threw in, you know, the concurring and dissenting opinions. The court still doesn't come out and say whether whether in fact they would be applying a strict scrutiny test to parental due process interests. They throw around fundamental, yet again, still don't sort of, so there's no, as of yet, Supreme Court opinion, unless you're talking about a First Amendment or a fundamental right. There's no Supreme Court opinion that says that the test to be used is strict scrutiny because the rights are as fundamental as one of the first 10 amendments. So the court doesn't get, it throws it around, then the concurring opinions talk about it, but doesn't quite get to that point. Now, a recent case that I threw in, mostly because I knew nothing about ICWA, the Indian Child Welfare Act, and that's adoptive couple versus baby girl. What were the facts of that case before we get into what the court held?
The facts, I can say them briefly.
Okay.
It was about a girl that was classified as an Indian girl because of some percentage she has from a Cherokee background. And because she was qualified that way, the Supreme Court said that
Can you back up and go to the beginning, as if you were telling it like a story?
So it was
So start with the two bio parents.
the birth mother was a Hispanic.
Mhm.
Birth mother was a
And where did she live?
predominant Hispanic, and this is
Did she live with bio father?
oh, you mean a child?
No, the two bio parents.
Actually, I think it was pregnant.
Yeah.
It was
yeah.
pregnant, so when it had some disagreement with the father, I think when she was born, it was born without the father, but it was the biological father wasn't living with her. And I think, if I can read it, it informed the mother that when the birth mother informed the biological father, lived 4 hours away, that she told her she was pregnant, and they said they're gonna wait. They wanted to do a wedding,
Yeah.
but eventually refused to financially support her, and the relationship deteriorated and it didn't go well.
Okay.
So they broke off the engagement. That was in 2009, and the mother sent a text message asking if whether pay child support or choose between paying child support or relinquish the parental rights. And father responded also with a text message that she would choose the latter.
Okay, so what does the birth mother then do?
Then went to get those two people who were willing to adopt the child. And just to make the summary, it was just eventually the father, when they learned about it, didn't complain, wanted to reclaim the rights. So the argument started. The argument was whether that was enough.
Wait, I just want to make sure we have the procedure correct. So she selects the adoptive couple.
Yes.
Okay. And what do they do procedure? Well, first of all, what does she do?
She after deciding they're going to put the girl for adoption, because also because of that statute that I said, okay, might be a Cherokee.
So mom is done.
Cherokee Indian, yes.
And then adoptive couple go where and do what?
The adult couple, I think, in South Carolina, South Carolina, and want to put on adoption, and they supported the mother throughout her pregnancy, and that was in Oklahoma. They gave the girl for adoption in Oklahoma. Then, but I'm not sure these are details that are important, but the adoptive couple, they say how they were present at the birth, and they cut the umbilical cord, and then the mother signed forms saying that she's done with the child.
Okay.
Yeah, so then they started initiating the adoption proceedings. But they allowed the visitation from the mother.
Yep,
From the mother. Then the father also said that she accepted services, that he was not contesting the adoption. That was biological father that we mentioned earlier. So, but then the father said, the father said, this is also also they took into consideration, the father said when they relinquished the rights, she thought it was doing it for the mother, not for these adoptive couples. So that was also...
when does dad get into the case procedurally, into the adoption trial?
Then I found it. Just a moment. Yes, the father or
So how-
the family court, when the case goes in family court,
Yes.
we mean the time or what happened?
I actually have a related question to that. So baby girl is with adopted couple because they took her after mom signed the papers, correct?
Right.
But then they had to, apply, become petitioners in South Carolina, and of course they have to serve notice and whatnot. How old is baby when the petition is filed? How old is baby when the case goes to trial? And where is dad in this mix in terms of relationship with baby?
Now that at the age of 27 months, that's when the baby was handed to the biological father. I think that was after they won he won the case.
For the first time?
First time.
Okay.
27.
When does father first object and want to be part of the case?
4 months in.
4 months in. Okay. Yeah, I'm just throwing this in as a note because Supreme Court, mentions in its opinion items like, he didn't want to pay his child support, that, he hadn't seen the child in 2 years and whatnot, but it's when the child is 4 months that the dad actually voices objection and wants to have some relationship with the child. Okay, can we back up for a minute and somebody tell me about ICWA and the provisions that the Supreme Court is going through in making its decision?
Or the Indians or the
Yeah.
adoption?
Yeah, the
Indian
provision of the
status.
statute, the ICWA statute, what are the important provisions that then play into the Supreme Court's deciding in favor of adopted couple? Elizabeth?
They cite 3 on page 59.
Yes, that's exactly it.
First, any
And
party...
you could just underline those or highlight them and
Did you want me to read them?
yeah,
Okay.
go ahead.
First, any party seeking an involuntary termination of parental rights to an Indian child under state law must demonstrate that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family and that these efforts have proved unsuccessful.
Yeah. Can you just stop for a minute, because later on when we talk about our state's parent protection cases and the Department of Children and Families, we'll be going through, the department's goal is to strengthen and encourage family life and help reunify, and there's a federal statute which also has become a state statute in Massachusetts, and you'll hear this term often, reasonable efforts. But very similar to that, has the state, made reasonable efforts, to help the family, to offer services, before, taking custody of a child. Okay, what's second?
Second, a state court may not involuntarily terminate parental rights to an Indian child in the absence of a determination supported by evidence beyond a reasonable doubt, including testimony of qualified expert witnesses, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child.
And of course, the Supreme Court really harps on the term continued custody and says, rationalizes in its opinion here that dad never had custody in the first place, and therefore that this particular section of the court doesn't doesn't even apply. And what's the third one?
With respect to adoptive placements for an Indian child under state law, a preference shall be given in the absence of good cause to the contrary to a placement with 1, a member of the child's extended family, or 2, other members of the Indian child's tribe, or 3, other Indian families.
And Dad also, brought up as many bio parents do in not only the Indian cases, but in the state cases as well. They try to look sometimes for other the state usually has some kind of duty to look to related placements. Are there relatives, are there, family members that are willing and able and whatnot to take the child. So the father, I think, there was some talk about grandparents, there was some talks about the tribe, which actually intervened in the proceedings at some point in time. Okay, so that's the statute. So Dad, as Jean-Paul said, Dad ends up actually getting custody in the state court, and then what, John?
He lets them talk to the parents the next day, and then he cuts off relations totally with the adopted parents.
I'm sorry, what? Oh, go ahead, say that again.
He lets the adopted parents talk to the child the next day.
By telephone?
Correct, and then he cuts off relations.
Okay, and then what?
And then they appeal.
Yeah.
And the court upholds the lower decision, the appeals court, saying the couple did not meet the burden of proving the baby girl would suffer serious emotional, physical damage if biological father had custody.
And you're still talking about lower courts now?
Yes, I'm
What-
sorry.
okay,
And the
what's
South
the-
Carolina Supreme Court
Yep.
affirmed it held 2 separate provisions. The ICWA barred biological father's termination of parental.
And those are the provisions that Elizabeth just read?
Yes.
Okay.
And it also stated that if the child had not been 256 Cherokee, the biological father would have had no rights to object to her adoption under one of the provisions. The Supreme Court overturned and gave the
Okay,
adoption.
so why?
Because they found that
So all the way up, basically, from father's sort of first involvement, right, in the adoption trial, when the child was quite young. Remember, he objects at 4 months old, even though he doesn't end up seeing and taking the baby. So all the way up, the father is winning, right?
Yes.
And now Supreme Court overturns that, John.
I thought it was, they said any time, like unless there is an exception, but they said if a child born out of wedlock, I think they also quoting the Oklahoma statute, 10 section 7,800, they said
But remember, that wasn't the case, and the court even presumed, the court doesn't even make the determination, even though adoptive parents had argued, hey, he's not Indian. The court said, okay, we're just gonna presume that, but,
they said, except,
but,
yeah,
right?
yes, except otherwise provided by law. The mother of a child born out of wedlock has custody of the child until determined otherwise.
Okay, but I need you to get to ICWA, because that's what the case is really about. Because the court, again, presumes that he's Indian, and therefore none of those other situations apply. But even though he's Indian, he loses because, John?
well, the ICWA was designed to address the removal of Indian children from Indian families. And here, there was nothing to remove because he never had rights in the first place. He gave up his rights. So that's he gave up his custodial rights.
One of the rationales,
Therefore,
right?
he shouldn't have been able to invoke 1912.
Mhm.
There was no relationship that could have been discontinued. The adoptive parents legally adopted him. They also talked about like public policy. It would discourage people from even getting involved in adopted kids if this were to be allowed. Any sperm donor, I think they said, would be allowed to invoke his rights. complaint.
This is the majority opinion's rationale.
Yes.
Elizabeth?
Just kind of going off that, like conveniently he wants now to establish paternity when he's approached that she's gonna get adopted by a different couple, when he has done nothing in the first 4 months of her life or leading up to her even being born to contribute financially or emotionally to her life. So like going along with what he said, there's no relationship to stop because there never was one.
Why? Why was there never was one?
Never was one. One.
You mean a relationship between him and his daughter?
Mhm.
And he never made any effort.
How do you know that?
Like, I guess the case says so, but
4 months. She's only 4 months old when he said, oh my God, no, I can't do this. He calls a lawyer. I want to get involved in these proceedings. I can't lose my parental rights. She was 4 months old.
well, he supposedly said via text message, not that that counts for anything, that he wanted to relinquish his rights when he was
True.
asked by the mother.
True.
And still, I think 4 months in, like, you should have been there when she was born. Like, to me, that's 4 months, she's never gonna get back. I don't have kids, but that's just me.
Yeah, and then you're right.
I don't- you
My
know,
Where's my
opinion-
parental rights advocates? Wait a minute.
No,
It's you guys, right?
We are
Fight back, come on.
parental, we are parental, but sometimes we will have to come to a consensus, because if you are really relinquishing the parental right via text message, it doesn't matter whether you're relinquishing the rights to the mother or the adoptive couple. That to me, even though I'm on the parent side, it shows that this father really
But
just
he
want
lived
to
4
give
hours
up.
away. They were engaged. You know, obviously, you're reading the review facts. Yeah, he says at some point, I mean, they end up breaking up, so he said, okay, you take care of her.
and take
But
over.
he makes the decision to intervene. I want, it's the parental relationship, and later on, one of the cases that you read is the Supreme Court case of Santosky versus Kramer, where the Supreme Court actually holds that before you terminate a parental relationship, parental rights, you have to show clear and convincing evidence of unfitness. So the Supreme Court, rightfully so, as John says, falls back on that ICWA is about, has to do with continued custody, that Indian children can, so to speak, be, ripped out of their traditional homes and placed in non-Indian homes. And also we have to respect the preference for the bio-Indian parents can't care for the children, the preference for, Indian placements as well. And furthermore, that these active efforts, the reasonable efforts, again, should be applying to, families that have, existing families, Indians families, to prevent the breakup of those families. But what I'm trying to get you to think about is really the reason for ICWA, again, and I'm not that much of a historian, but the reason for affording these, Indians, the indigenous people of this nation, certain rights because they've been so hurt, right?
Yes, I will agree with that, but also for the parental rights, and if you look at the mother perspective, from the mother perspective, she also has some rights, and if she
The biomother.
the biomother, and that is also the decision.
And it looks like what she had, not to interrupt you, but sometimes we'll be talking about open adoption. So she had a relationship with the adoptive parents, and so was able to, even though her rights get terminated, to have some, some communications, with the child. Now, in order to terminate his parental rights, because he did not sign, they had to give him notice.
Right.
And that's when it dawned on him, I'm gonna lose rights to this child forever. My family, my tribe, etc., let me see what I can do. My child has the right to live with our traditions. Sorry, can you tell I don't
I do
agree
get
with
that. I
this?
feel bad. I feel like I sound like a terrible person. I do get it, like.
And you know, it's
he's her
hard, because
biological
we'll be
father.
talking about cases where, you know, even children that are neglected and abused still love their parents, still want to
Yeah.
be with their family. And that's why it's the state's duty to help, to protect, to offer services, to figure out, yeah, it's all nice and well and good that you have an adoptive couple out there with the nice home and, you know, the means and so forth. But it shouldn't be only for best interests, it has to do with parental rights as well.
Yeah, and I didn't mean to sound
No,
like I was,
no.
you know, gunning for the child and everything, but, you know, I know that the biological relationship between parent and child supersedes everything, and I get that he was.
Yeah, but it's not absolute.
Right.
And right,
Right.
and that's what it's all about.
Yeah.
Katika?
I mean, I feel bad for the father, but I kind of agree with what Elizabeth is saying, just
Don't
because.
just feel bad, think about the rights and interests and talk
Well,
legally
yeah,
as well.
I mean, I think about it in the way that when he found out that the mother was pregnant, he did not show any kind of support whatsoever. Like, forget about the fact that once they broke up, there's nothing in the case, at least, that says that he tried to have some kind of a relationship. But even when they were engaged, he refused to show her any kind of support until they got married. So in my eyes, I feel like that's just, there was never any connection between him and the child, and all of a sudden 4 months later, he's like, no, I want to fight for this girl and I want her back.
Okay.
Skipped out on all the hard stuff, I guess. Wow.
John?
I could jump on the state side, kind of play devil's. I think they did say early in the case that they did try to notify him, but his name was spelled wrong. They couldn't notify him through something accident.
Yeah, there was a problem with the registry at first.
So had maybe he been notified earlier, this
Right.
would even took place even a couple months,
Exactly,
four
yeah.
months.
Mhm.
I mean, I agree with these guys, but I'm just playing devil's advocate.
And I guess that's what the Maury show's for, right?
And I don't know if this is the last paragraph of the case, but it's very telling. It does say, and the court does recognize, ICWA was enacted to help preserve the cultural identity and heritage of Indian tribes. But under the state Supreme Court's reading, the act would put certain vulnerable children at a great disadvantage solely because an ancestor, even a remote one, was an Indian. It is what it is, and obviously, in a way, it is we have sort of a third party involved. You've got the state winning and adopted couple. Just put ICWA underneath it. As a practitioner, if you end up doing care protection cases, you occasionally run into, there's a whole specialty in and of itself, the ICWA cases and the provisions of ICWA. Okay, so let's talk about golf, because up until now it was substantive due process rights of the family. Now we're talking about procedural due process. It's still the 14th Amendment, but procedural due process, and obviously now we're looking at the child's point of view. So let's just, let's summarize what happened to Jerry. Oh, first of all, what Jerry did. Bad Jerry.
Do we know whether he did anything?
All right, allegedly, what did Jerry do, John Paul?
He used obscene language or rude remarks to a 78 years old neighbor.
Mm-hmm.
He used even to help
Mrs.
this
Cook.
neighbor. I don't remember the name. I used to help her do the chores. She didn't even have to ask to come to do the chores. They would come and volunteer, even though it wasn't just him, but some others he initiated. I think there's an additional fact that you get.
Yeah, don't take my facts
Okay.
yet. Let's talk about the actual Supreme Court
The
case
actual, before your fact, the additional fact is that somebody called, it was over the phone, when this lady heard remarks and said, am I talking about your facts?
Okay. Mrs.
William, you want to help?
Mrs. Cook
Yes.
called the police
Yes,
and
yes,
reported that the kids called her
right,
and used the vulgar language
yes.
against her.
Okay.
So the police went into Jerry's house where the parents were not in
That's right.
and took him into custody.
And who else did they take?
Jerry's friend,
Ronald or something like that.
Ronald.
yeah, Ronald. Yeah. So when the senior brother came home, when the mother came home, he asked the senior brother to go out to look for
Right.
Jerry.
Yep.
So he went to the trailer,
Yep.
Jerry's, the friend's house.
Right.
And that was where they learned, the first time they learned that Jerry had been taken into custody.
So where, he was in custody where?
And then in that city, industrial something.
Like a detention sort of
Yeah.
place?
Yeah.
Okay.
So then Officer Flack,
Mhm.
Officer Sheriff,
So we had Flag and Henderson. What?
yeah, and the judge, they initiated the proceeding of assault.
Okay.
Yeah,
And
where
so who goes to that proceeding?
it was the
Because
man,
that's what the first play act will do, will be that proceeding.
it was Jerry,
Mhm.
the mother,
Mhm.
and the brother. The father wasn't at the first
Right.
proceeding. And the
And
judge,
what other personnel were in there?
the officers were there,
Yeah,
and the judge.
and the judge, okay.
So they proceeded in questioning the boy without, any Miranda warning, any right to counsel,
And
warning.
Mrs. Cook too, I think she was.
No, Mrs. Cook wasn't there. The
No,
only
Mrs.
thing was
Cook.
the
That's what- yeah,
telephone
that's what I'm saying.
conversation
Mhm.
that was between the police officer and Mrs. Cook, that's it. So without any of these constitutional rights being made available to Jerry, in the course of the interrogation, he testified against himself.
Okay.
So,
Does Jerry have a record at the time?
yes,
Yeah,
because he
what was
was in
his record? What did it consist
probation,
of?
because
Probation for 6 months.
he was in probation, he was in the company of a friend
Yeah.
who actually did something, not him.
Yeah.
Yeah. So the judge during the cross-examination said he factored in that probation
Mhm.
and some other theft that occurred
Mhm.
into his decision that Jerry was habitual bad character
Yep,
person.
yep.
And
And so what does the judge do with Jerry? At the
Um,
conclusion of the trial piece of it?
she found against Jerry
Mhm.
and remanded Jerry to six years, I think,
Yeah,
because
so
although
he's
she was 50
committed.
and 20, yeah, committed. So
Okay, so how does Jerry get it?
They had
Jerry
no
gets to
right.
the Supreme Court?
At the state level, they had no right to appeal in juvenile cases.
Mhm.
So the only option was to go through the habeas corpus
Yes.
for them to produce.
And
the
that's
body.
why it's called in re galt rather than like state versus a commonwealth. Yeah,
It's for the body of the child to be produced.
yes.
So at the habeas corpus hearing, I think the judge, at the habeas corpus hearing, they affirmed,
Oh, you're still at the state level now?
yes,
Okay,
they
okay, go ahead.
affirmed
Okay,
before it went to the Supreme Court.
okay.
It was at the Supreme Court that they found out that the denial of all those rights,
So let's stop you right there before we articulate what the Supreme Court announced in terms of juvenile rights. We talked with the earlier cases about the nature of the parents' rights. Now we're talking about procedural due process. And it's basically, you want to think of two questions. Because we get into procedural due process also later on, for example, with the student rights cases, the delinquency cases. Is process due? Question number 2, why process is due? So depending on the answer to number 1, number 2 might be a lot of process or very little. So in terms of, we're still looking at the 14th Amendment, so what are the 3 rights under the 14th Amendment?
14.
Yeah, the 3 interests. 14th Amendment, no state may deprive life, liberty, property. Okay. So is process due? You have to answer whether the person involved has either a life, a liberty, or property interest. And so what interest does Jerry or people like Jerry have?
I think the first 2, life and liberty.
Well, let's not go to life yet, because we'll talk about the death penalty and juvenile life cases after, at some point, but let's talk about liberty. And the argument used to be before Jerry that, you know what, the children's cases are different, that the state intervening as parents patriae wants to really protect and rehabilitate kids, and we're not going to, you know, incarcerate them the same way that we do adults, that wherever we place them, it's to rehabilitate and protect them, and therefore they, you know, they really don't have a similar liberty interest as the family or parents, you know, would have. This was obviously the case that overrode that earlier sort of thinking. So because Jerry was ultimately committed to, you know, a place where he couldn't leave, right? In spite of the fact that it wasn't an adult jail, his liberty is at stake, therefore he has some kind of liberty, 14th Amendment interest. And because it's, again, akin to adult commitment, in spite of the fact that it's different, the process that is due is, you know, the most, a lot of process. And so therefore the court went through and 4 basic rights that the Galt decision stands for, that applies to children, and because of the fact that they are children, especially as to the notice requirement, applies to the family as well. You mentioned that, or Jean-Paul, the 2 of you started talking about that when Jerry's parents came home, he wasn't there. They didn't know where he was. In fact, he had already been taken, and they received, you know, no notice of the charges. In fact, when they, learned from, you know, the neighbor Ron, and that Ron had been taken as well from Ron's older brother or something like that, and went to the home, they were just told orally, remember, to just come the next day. At some point, they got a written piece of paper, but the notice of the charges should be ahead of time. It should spell out the specific allegations.
They criticized.
Later on, I'm sorry, go ahead.
I said they criticized also the plain of paper itself also wasn't really good enough because it didn't have a letterhead, it didn't.
Exactly.
It was just something the sheriff wrote as not a professional.
A notice with specific allegations of the charges that again has to be given to, that the family has to receive that notice, the family that has custody of the child, whether it's by a parent, guardian, etc. And the notice has to be ahead of time notice. For example, later on when we talk about student rights cases, because they do have some sort of interest, but not as fundamental as this type of liberty interest. I mean, you don't have an absolute right to be in school, for example, but you do have some sort of interest. Well, your notice could be nothing more than, Nick, you broke a school rule, go home. I don't need to put you anything in writing. I mean, you might end up, you have an opportunity to be heard, so it's notice and opportunity to be heard. It's sort of the lowest of procedural rights, but he gets, in addition to notice, what else? You mentioned it.
Yes, okay, I have them here.
Mm-hmm.
There was no notice was given to the parents. They were orally informed of a hearing. They didn't allege fact that supported the possible claim. Right to counsel.
Right to counsel. So let's stop there and talk about right to counsel just for a moment. So when you think of right to counsel, it applies and attaches, or it doesn't apply, for example, in civil cases. You have a contract case, you're on your own, right? This is, again, the first time the Supreme Court articulated that just like adults who are facing a loss of liberty, are told that they have a right to have an attorney, and if they can't afford one, an attorney will be provided for them. A juvenile, again, going back to the fact that because his or her liberty may be restrained as a result of these proceedings, that particular person has a right to counsel because the proceedings could result in commitment. So notice, number one, right to counsel. Number two, somebody give me a number three. Confrontation and cross-examination. Mrs. Cook wasn't there. That's why when we do our third little mini hearing, Mrs. Cook will be there. And remember, the mom asked, right from the beginning, who is this person? Where is she? Oh, she doesn't need to be here. There's a very good sort of, within the opinion itself, is a very good sort of overview of the juvenile court. It's historical, how it started, and the reason for not affording rights like this, again, had to do with protection and rehabilitation and informality of the proceedings, that, the court, the judges, the probation, etc., would know what was best, for the children that came before them. And finally, the golf court sort of puts kind of a stop to that in terms of these particular rights. And what's the fourth one?
Privilege again, the fourth is privilege against self-incrimination.
Yes, exactly. So the Sixth Amendment was confrontation and cross-examination relative to Mrs. Cook. And then William mentioned before that Jerry actually was questioned and should not have been questioned without him affording his privilege against, his Fifth Amendment privilege against self-incrimination. So Jerry should have been informed that he didn't have to testify, and of course he could waive that. And we'll talk about waiver of rights later on too, in terms of mature children and who can effectively waive, and it's only those four. People sometimes think that because he argued for an appellate review as well, there were two other arguments that he made.
Transcript,
and which are afforded by many state statutes anyway. It's only those four rights that are part of the majority opinion of GOLT. So what we will do, and I'll leave time, we can, because of the storm and people not being here, obviously, we can save the exercise for Tuesday. So what I thought we'd do, and I emailed everybody the exercise and I assigned roles to people. So the first hearing is very short, it's just that initial coming into judges' chambers and really put yourselves into the role. The parent, mom and dad and older brother are, concerned. Anthony's not here, but I have him playing the older brother. I actually told him to listen to the audio later on. You might have, for example, the older brother is pissed at Jerry for getting into trouble. So, don't be afraid to raise your voices and, put yourselves into the character. And obviously, it's just in camera, just before the judge. It's very, very, very informal. And then he has to go back to the home because remember, he's not released that first day. So the second hearing is really Jerry's arraignment. And that's where he gets, he would have had notice at arraignment or before. He would get, if he couldn't afford counsel, he'd have his right to counsel and he'd get counsel. In fact, in Massachusetts, even if you're arraigned, obviously it's so quick that you might not have a lawyer right away. Well, we have the various lawyers that are on the lists and are on duty that day. So if there's a question of, the person is just before the court for arraignment, that's normally very quick. But if there's a question of bail, should this person actually be allowed to walk that day and then come back for the next, you would have an attorney, talk with the defendant. By the way, some courts and some attorneys call the kids defendants. Some call them juveniles because they're not really like adult defendants, but again, there's that conflict between is it like an adult case or not. But for Jerry's arraignment, it would be the formal sort of reading of the charges, the defendant slash juvenile deciding, for example, whether to waive jury trial, deciding whether to waive counsel or not. Commonwealth might be bringing up a question of bail, but no hearing like as to his guilt and innocence because it's only the arraignment. And then the actual trial is when the Commonwealth has to prove beyond a reasonable doubt through its own witnesses and proof that the defendant in fact had committed that crime. And I thought we'd have a little bit of fun with it with somebody. Who do I have as Mrs. Cook? I forget. Oh, Sharon. Sharon's not here today either. That would be, testifying as to the facts, and then obviously she'll be cross-examined as well while she's testifying. The other side could be objecting, to evidence, for example, that's not relevant, or hearsay. On cross-examination, questions obviously come for a yes or no answer. You don't ask questions on cross-examination unless you know the answer. On direct examination, you can't lead your witness, otherwise it's like you're cross-examining them, so you want to kind of think of things like that. A very abbreviated sort of short hearing that we will have. Any questions on what we'll do? So we'll save that for Tuesday, and we'll actually start the students' rights stuff next Thursday. Yes, no questions, complaints?
Is it the same? Is it still the same on a transcript for the because the court ruled in this case that it didn't.
So it's not a federal right. So this is important. So you have the feds, Supreme Court SCOTUS, deciding sort of the stage by which your clients can argue relative to their federal constitutional rights, and it's the minimum rights that they are afforded. So if you have somebody like Jerry, a juvenile that's charged with delinquency by reason of, say, assault and battery, and he doesn't get any of these rights, that means his federal constitutional rights are violated. If instead, for example, right to jury trial, one of the cases that you read later on is MacGyver versus Pennsylvania. The U.S. Supreme Court actually held that juveniles don't have a right to jury trial. However, Massachusetts, in this case, as in many instances for Massachusetts, affords more than the federal constitution. And Massachusetts, both juveniles and adults have right to jury trial. So in terms of the question that you asked, transcript and so forth,
yeah.
that becomes a state right because the feds did not rule on it. The Supreme Court said, we're not touching those, we're going to give you these four, and that's it for now. Elizabeth?
That just made me think of it when you said in Massachusetts. With regard to the final, are you going to be testing like Massachusetts juvenile law, or is it kind of just like everything?
Well, it's Mass and U.S. because again, U.S. sets the limit, the minimum limit by which we have to follow.
Okay.
Do you know what I'm saying?
Yeah, because we were reading a lot of U.S. Supreme
Because
Court
we have
cases.
U.S. and we have Mass, basically. So,
Okay.
and we're going through the Mass statute, Chapter 119 is the Parent Protection Statute, 210 is the Adoption Statute, 119 covers both the neglect and abuse, the delinquency, the youthful offenders, the CRAs, the children requiring assistance. So, and Massachusetts is a model, no matter what other state you go to, very, similar procedures.
Okay, good. Just
Yeah.
when I'm outlining, I just want to know
Yes.
how to set it up in Mass and federal.
Yes.
But in the cases of these juvenile cases, if you don't trust the judges or the decision of the court in this instance where you destroy or some records get destroyed after a certain period of time, it's really sometimes
You're screwed, and you know it because you're in the court system all the time.
I thought it was